So if you're an individual, it's your LLC, it's your trust, you're signing in both capacities, and that's it. Hi, Jeff Versace, the Plain English Attorney, and welcome to the video. Today we are going to talk about the 5 keys to limited liability companies and revocable trusts. So what exactly are these entities? Let's start out with that. A limited liability company is a way of putting corporate protection typically around assets as well as the business operations. And a revocable living trust is a way to avoid probate and to handle transferring control if you become incapacitated. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. It's a structure that a lot of estate planning clients use, but how do these two things work together? All right, so with limited liability companies, why even have a limited liability company? This is the first key. It's to have corporate protection around an asset. Now, what's very typical for most of my clients, if they are involved in some kind of business, they're a small business owner, that could be a corporation, it could be a limited liability company. There are other structures that are out there very specifically, but a lot of my clients have rental property, and we're not talking about tons of them, but they might have 1 or 2 properties, they're renting it out, and what they're concerned about is having corporate protection in case there's a lawsuit. They don't want somebody slipping and falling on the porch and, oh, I'm gonna sue, this was wrong, you should have repaired this, and I'm going to take all of your personal assets. All right, so the limited liability company is a way that you can section off, here's what's in business, and the asset is typically a checking account and the actual property. So even if they can get through into that lawsuit through the limited liability company, that's what's at stake. Now, in North Carolina and most other states, there's actually even more protection. We don't need to necessarily get into that. That might be a good subject for another video. But for now, limited liability companies are a way to protect those types of assets. So that's the first key. Second key, what are the different roles in each of these entities? So with the limited liability company, you have the members. Those are kind of like the owners. There's also a manager. So a manager can be in place. They're the ones handling day-to-day operations. Now, for the most part, if my clients are doing their estate planning and it's simple, maybe they've got 1 or 2 or maybe even 3 rental properties, it's not something that they have to work on every day. They're going to be both the member and the manager. And there are some LLCs that don't even have managers. It's just the members do everything. The way to think about an LLC is it grew out of the partnership. So, okay, 2 people own a business. They're in it. They're running it every day. They're members. You've got much bigger operations where people are just putting their money in and they're not expected to do anything. That's a shareholder. So really the limited liability company growing out of that partnership, they called it members to distinguish it from partners because it was a separate corporate entity. Now there are single member LLCs that are out there, and I have clients that have these LLCs. They're the only member because after these LLCs started as a partnership, it's like, well, why can't one person use this corporate structure? And the states responded and said, sure. So you've got these limited liability companies. For most of my clients, they are the member and the manager. It doesn't necessarily have to be that way, but that's the way it ends up. With a revocable living trust, if it's an individual or a couple, they're the trustors. So they're the people setting up the trust. They're also the trustees. So they're the people managing the trust. And they are also that first level beneficiaries. And then all the estate planning stuff, who gets what if we die, all that stuff's in the revocable trust at the same time. So those are the different roles. Now, here's one key thing that they have in common, and that's taxation. By and large, your taxation, it's all kind of see-through. If you're the trustor or the trustee and the beneficiary of the revocable trust, you don't have to file a separate tax form each year for your income and capital gains and any of that other stuff. No, it just passes right through and it ends up on your 1040. With a limited liability company, for most of my clients, it's the same thing. They're just using their social security number, and it may have a separate tax ID number for the LLC, but they're not filing a separate return. It's a see-through entity. So again, it goes onto their taxes. So for taxation, with these different roles, it's all the same. It just goes through onto your 1040. So that's the second key. All right, so let's talk about a third key. Now, this is really going back to law school. I mentioned with limited liability companies that if you have a limited liability company set up, you put your, let's just keep using the rental property, you put the house in there, there's a checking account for the limited liability company. If there's a lawsuit, that's what's on the table. Well, what if you do have 3 rental properties? If you put all 3 into the same limited liability company, then all 3 assets are on the table for one lawsuit because somebody got hurt on one property. Well, how do we divide that up? So again, this is going back to a law school case. And if you've been through law school and business law, the taxi cab case. This is the easiest way for me to explain it to my clients. There was this lawsuit that came out of New York City. This cab company, kind of an overarching holding company. They're the ones with the brand. They had 300 taxi cabs, but they didn't have 300 taxi cabs under their one company. What they did instead is they set up 100 different LLCs, put 3 taxi cabs in one checking account in each one, so that it limited that liability to those 3 cars in that checking account. So one taxi cab got into a big accident. There was a huge lawsuit. What was on the table? 3 taxi cabs in a checking account. And they tried to get through. No, this is this big company. It's this big company with big pockets, and we need it. And well, no, the corporate protection kept it limited. So that liability was based on whatever insurance there was, and those 3 taxi cabs in the checking account. So they still had 297 cabs on the road that were completely unaffected and separate. So how do you do this with your own limited liability company and rental properties? If you've got those 3 rental properties, consider having each one in its own limited liability company. So now if there's some kind of slip and fall accident and there's a lawsuit or something else goes wrong, you've got your other 2 houses that are completely unaffected in this process. So that's the third key, is you can, quote, taxi cab it, so that you have separate individual limited liability companies and therefore also separating your liability, not just from your personal assets, but from these other LLCs. So what is the fourth big key? The fourth key in this process with limited liability companies and revocable living trusts is the avoidance of probate when you pass on. So how is this actually working? You've got a revocable living trust that keeps your assets out of probate. You've got your limited liability companies, okay? That's an asset that could end up in probate. But the revocable living trust, in avoiding probate, this is all based on title. And this is the secret that a lot of attorneys will not give you when they're talking about wills versus trusts and avoiding probate. Look, let's just boil it down. Probate is about transferring title from a deceased person over to the beneficiaries. That's all it really is when you come down to it. What ends up in probate is what's still titled in your name after you pass on, and then it needs to get transferred to the next level beneficiaries. Well, in order to do that, you have all of these inventories that need to be filled out, exact date of death values, and you have to have all these backing up statements and other writings from the institutions. Yes, here was the exact value on the date of death, and we have to, if there are expenses, we have to show the copies of the canceled checks and line them up with the info. Oh my God, it's a tornado of paperwork, and you want to avoid probate. Okay, we'll put all that stuff into a revocable living trust. So even though you're the trustor, you're the trustee, you're the beneficiary, you're still controlling everything, it's not titled in your name for probate purposes. As I mentioned before, it is totally on you for all the taxes and going on to your personal tax return. But as far as probate's concerned, you don't own it. So that's a key when it comes to revocable living trusts in this part. So now let's get to the fifth key. How are we keeping the limited liability companies from going through probate? A lot of people just assume, oh, it's a corporate entity. It just kind of goes, well, no. If you have a brokerage account and you've got 1,000 shares of IBM stock, they don't just magically avoid probate because it's stock in a company. Therefore, really, your LLC interests, they do not just magically avoid probate because those interests are titled in your name. All right, so now to make the LLCs work with the revocable trusts, you're assigning your membership interests into the revocable living trust. You still stay in control of it as the member, but also as the trustee of your trust. So you've moved it in. So in some cases, the easiest way to do this, and you got to check your operating agreement first if you're allowed to do this, that you're just assigning your membership interests, but you're maintaining control of your LLC interests as your name, comma, trustee. That's it. There's a very simple form in North Carolina that we use inside my office, and it's just acknowledging that it's transferred, and you're signing it as both the owner of the LLC interest, that you're transferring it in, and it's acknowledged by the trustee of your revocable living trust. So if you're an individual, it's your LLC, it's your trust, you're signing in both capacities, and that's it. It's signed over. It avoids probate. Now, I mentioned you have to be allowed to do this through the operating agreement. And it used to be, look, it's about 50-50 whether the language is in there. Because limited liability companies, as I mentioned, it's kind of like partnerships. You don't want someone just selling their partnership interest and having somebody you don't know come in and have to manage the business. Well, okay, the limited liability companies don't want members to just be able to sell their interest to whomever they want. And now they're stuck with a new member who's supposed to be potentially contributing, and they have no idea who they are. So there are a lot of restrictions that you cannot sell it outside. It has to go through this process. The other members have to have the ability to purchase the membership interest themselves. And so that's a very typical thing. But this one clause that you're able to transfer your interest into your own revocable living trust or other entity, that was about 50-50. In recent years, as I review these operating agreements for my clients in North Carolina, I'm seeing it's more about 60% allowed these transfers and the other 40% don't. Well, what if it doesn't? Well, okay, that's when it's a good idea to amend and update that operating agreement. Now, like I said, for most of my clients, if it's just them and it's a rental property, it's an easy thing. If it's actually a running business concern, where you have other outside partners, people who are not part of the actual revocable trust, they're not part of your family, they're not part of your planning, you're dealing with outside people, they kind of have to agree to it. But I have not really seen any resistance. It's like, well, yeah, it's still you, and if you pass on, there's a mechanism for handling it anyway. Why have to get the court involved? Let's put it into the revocable trust. And usually the other members at that point start saying, hey, wait a minute, maybe I need to start looking at my planning, and maybe I need to kind of move this into my revocable living trust. So those are the 5 keys on how LLCs and revocable living trusts work together. Here's the biggest problem that pops up. So this is a little bit of a bonus tip. People who have these rental properties inside a limited liability company already, as we're getting things set up with their revocable trust. Oh, do I need to deed my rental property into the trust? No! It's already in that corporate entity, that LLC. You're not moving the property. you're moving your interest. Think about it as a toiletry bag where you've got your toothbrush, your razor, and all this other stuff, and it's in a bag. And your revocable living trust is the suitcase for going on a trip. Well, the toiletry bag is your LLC. Do you open it up and dump everything directly into the suitcase? No. You just put the toiletry bag into the suitcase. That's how it works with an LLC. Whatever assets are in the LLC remain in the LLC. You move the LLC interests into the revocable living trust, and now your, quote, suitcase is packed. That's the way it works. So I hope you found that information useful. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.